When we think about workplace discrimination, I mean, you usually picture the really dramatic version, right? The screaming boss, the obvious
The
insult.
low-level version.
Exactly. But looking at this legal breakdown from HTW Law, and these folks are top-tier employment lawyers in Canada for 2026. That version is almost, the easy one to prove.
The reality they describe is so much quieter, it's subtler, and often it's invisible until it's way too late.
And that's the danger.
Yeah, because the focus in Ontario law isn't about whether a manager meant to be a villain, it's strictly about the impact of their actions.
That distinction, intent versus impact, that's exactly where I want to start. Because some of these case studies, at first glance, they just look like someone being nice.
That's the concept of benevolent discrimination. It's probably one of the most counterintuitive parts of employment law.
Sounds like a total contradiction.
Yeah.
But okay, take the married man scenario from the source. You have this guy, he gets married, and then all of a sudden, he stops getting offered promotions for roles that need weekend work. The boss isn't saying, I don't like married people. He's saying, hey, I don't want to take you away from your new family.
And that's the trap. It feels like a favor. It really does. But the legal problem is the employer is making a paternalistic choice for the employee.
Right.
It's based on a stereotype about family status. They aren't asking, hey, are you still available for this? They're just assuming you're not.
So it's a professional ceiling, just disguised as consideration. The source points to a really similar dynamic with ageism.
Oh, yeah.
The hiring manager turns down a woman in her 50s, not because she's too old, but because, they want someone who will stay for a long time.
Precisely. It masquerades as just business logic. And we see this same bait and switch with maternity leave. An employee is pregnant, her duties get lessened to help her out.
Which sounds great.
At the time, sure. But when she comes back, those duties are gone for good, and suddenly her role has been dissolved.
It makes it so hard for the person to even trust their gut. I mean, if your boss frames it as helping, you start to gaslight yourself, don't you?
Oh, absolutely. You wonder, am I being targeted, or are they just being considerate? That self-doubt is a huge barrier.
And what happens when we move from that quiet discrimination to actual harassment, like sexualized comments or belittling?
Well, the source material points out that the barrier sort of shifts from confusion to just fear.
And it's a very specific fear. It's not just, I could lose my job. The notes mention this fear of personal secrets being used against you.
That's a paralyzing dynamic. If the harasser is a mentor, someone you've confided in, they suddenly have all this leverage. They rely on that closeness to keep you silent.
Wow.
But HTW Law makes a really crucial point here about the bystander effect. Reporting it isn't just about you. It's a protective measure for everyone else.
For the whole workplace culture.
Exactly. If you don't document it, the next person just walks right into the same trap.
Speaking of documenting things, we should pivot to where waiting is, fatal to a case. Disability claims.
This is where the clock is loudest. Whether it's a denied short-term disability claim or an employer refusing to accommodate you because they say you aren't fit, that evidence evaporates.
Emails get deleted, people's memories fade.
Yeah.
And the whole procedural landscape for this has just had a massive shift. I was reading about this update to the Human Rights Tribunal of Ontario, the HRTO. As of June 1st, 2025, the rules are completely different.
It's a huge pivot. They've brought in mandatory mediation for all new applications.
This is so interesting. Usually you file a claim and you expect a fight. But this forces a conversation first.
Right. Unless you get a very specific exemption, you have to try to talk it out before you ever get a hearing. It completely changes the strategy.
How so?
Well, it moves the whole process from, I'm going to beat you in court, to a structured negotiation right at the start. It means you have to have your evidence perfectly organized before you even file.
So the days of filing a vague claim and then just hoping to find the evidence during discovery are over.
They're gone. You need your receipts on day one because you're walking straight into a mediation room. Whether it's that helpful boss or a denied claim, the timeline is just so compressed now.
It all just reinforces the main takeaway here, doesn't it? Silence and delay are the enemies of justice in the workplace. If something feels off, you have to document it right away.
Knowledge is your leverage. And just recognizing that, kindness can actually be discrimination, that's the first step.
It leaves me thinking about that married man example again. It really does blur the line between professional empathy and an actual legal violation. At what point does a boss's consideration for your personal life stop being a perk and, start being a violation of your human rights? This is something to think about.